Hey everyone, welcome back to the channel. Today's video lineup is packed. We've got 3 wild courtroom moments you won't want to miss. First up, we're heading into Judge Shackelford's courtroom where Phil and Judge is taking over for the day, and honestly he sounds almost identical to Judge Shackelford himself. Then, we'll move on to 2 separate cases where defendants learn the hard way that attitude and courtroom etiquette can make or break your day, both ending up with some unexpected jail time. But let's not waste any more time. Grab your seat and let's jump right into the first case.
Calling case 251851 OM, People versus Alyssa Hall.
Morning, Your Honor. Deputy Pantone has Ms. Hall waive formal reading, stand mute, request matter be set for settlement conference and discovery order to enter.
Ms. Hall, can you say your name for me, please?
Alyssa Hall.
Did you go through your advice of rights with your attorney, Ms. Hall?
I did.
Okay. Did you have any questions about your constitutional rights?
No,
And did you allow him to sign your name to your advice of rights?
I did.
Okay. And so in front of me, I have an order for discovery. I will have that signed. We're going to be adjourning this for a settlement conference for your attorney to get the discovery or all the evidence that the other side has. For purposes of arraignment, I'll enter a not guilty plea. Ms. Hall, you're gonna have some bond conditions. You're to appear in court as directed. You have a $1,000 personal bond. I think I missed that. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any crimes while released. And you're to immediately notify the court of any change of address or phone number. Give me just 1 second.
I do have a question on that. My bond was returned to me.
You don't have to post any money.
Well, I know
first
that,
of-
but I thought all bond conditions were done because the bond was returned.
Well, Ms. Hall, we're doing the arraignment now, which is we hadn't done before. So she's going to give you the bond conditions, but the bond, the monetary bond is personal, means you don't have to post any money.
But you still have to adhere to the bond conditions I just stated. Do you understand? Yes or no? Do you understand, or do you need me to go through them again?
I suppose.
It's a yes or no question, Ms. Hall.
I don't understand how there is still bond conditions when my bond was returned, but that's apparently something else according to my lawyer, so it is what it is.
No, I'd be happy to explain it to you. So you're on bond. So whenever you have a pending case, you are out on bond. Instead of being in custody, you're out on bond. I'm giving you a personal bond, which means you don't have to post anything, but you still have to adhere to your bond conditions. You can't go and commit a murder when you have a pending case. Does that make sense?
Not exactly. You can't violate a bond if you don't have one, but once you're out on bond with a pending case, even a minor offense like disorderly conduct can land you right back in custody. In this situation, she was initially arrested for domestic assault and later released on bond. The case was dropped for a short time, but then the charges were refiled, which means this is actually her second arraignment for the same offense. It's a perfect example of how quickly things can spiral when you're already under court supervision.
So this is a new case then off of that original case, because I originally got that bond back and told that nothing further was going to happen. And then all of a sudden I was told I missed a court. So I'm still confused. Is this not the same case?
Okay, so we're gonna do a full arraignment, okay, Mr. Panto?
I'm just confused.
I understand. I'm going to go through it with you because that's part of the arraignment, is to understand what you're being charged with. So give me 1 second. Let me
I'm
pull
being
up
charged for disorderly conduct at my brother's house. I understand that.
That's the
But-
charge.
The day my bond was returned and they sent a letter stating nothing is going to happen at this time. And then
And I'm. Go ahead.
They have the right to review and file charges, which they did, and that's why we're at today's point.
all right, can we
So
discuss-
they reissued the charge, and I'm reassessing a bond, which means you have bond conditions because technically you're out on bond. I'm assessing you a $1,000 personal bond, which comes with bond conditions. So I see where you would get confused if the one before got returned to you, but we're back at it. They reissued this case.
I just don't even understand how they reissued the case because it was my brother kidnapped my kids, but it is what it is. I have my own issues with Taylor Police Department and everything else right now that I'm going through, so.
Okay, well, you're the one that has the case. So you're the one that has the bond conditions in the jurisdiction of this court, Ms. Hall. Do you understand your bond conditions, yes or no?
Yep. I know that my lawyer requested discovery.
I'm
but I
not
would like-
talking to you. There's no question. So give me 1 second. I'm looking the report over.
Ryan Lupica is the.
Is there a place?
There's an address.
That's what I'm looking for.
It's Ryan
It's
Lupica.
on Marvin Street in Taylor.
Ma'am, give me a second, okay?
This is why I hate paper.
I didn't explain to her that the court would require she have no contact with Mr. Lupica or his address.
Yeah, I just need for the
I
bond
don't talk
condition.
to my brother.
Ma'am,
Okay.
enough.
Don't talk.
Honestly, you're just digging yourself a hole right now, so just stop.
I'm not doing anything.
This hall, it's easy here.
Marvin Street.
Yes.
Okay. Okay, you're also gonna have no contact with Ryan Lupica or 13685 Marvin Street. When I say no contact, Ms. Hull, I mean no contact. That means you cannot email him, call him, or text him. That means nobody can do those things on your behalf. I see you're listening, but I don't need the attitude. You cannot send a text message, a tweet, an instant message, or anything of the like. That includes contact on Facebook, Instagram, Twitter, Cash App, or any form of electronic communication whatsoever. If you have him added on any form of social media, you are to delete him immediately. Sending a blank message is considered to be contact, since I'm instructing you to take specific steps to make sure that does not happen. If the communication comes from you or by the direction of you, it will be considered contact, and it will not be a defense that you accidentally contacted him. If he contacts you, you are not to reply. If he's at a public place, such as a store or a park, and you see him, you are to leave immediately. This is the order of the court. The victim in this case cannot change the order, only a judge can. If he were to invite you over or to ask to meet you anywhere, and you do so, that is a violation of this court's order. If we need to change this order at any point, we will have a hearing with both parties present. Do you understand that?
Yeah, my brother's dead to me. I don't talk to
I'm sure her brother's enjoying the peace and quiet that comes with her being ordered to stay away. Hopefully, she takes that advice seriously, keeps her distance, follows her lawyer's guidance, and drops the whole temper tantrum act. Because if she doesn't, she could easily end up like the next person we're about to see, the one who managed to get himself arrested right in the middle of his own pretrial hearing.
Daniel McGregor. All right, Mr. McGregor, this is cause number CR 24172, and we're here on a status hearing regarding your hiring an attorney. Tell me where you're at on that.
Yes, sir. I had brought the paperwork that I needed to prove contingency. I brought the pay stub and the worth of my car. And right now I'm in between jobs, so I got approved for unemployment temporarily until I can get another job. I'm just waiting for those deposits to come through because sometimes they take a while to review. So currently I'm waiting for that to process.
Do you know how long that's going to take?
Usually they said about 6 weeks sometimes to receive payment, but I'm still looking at jobs and I've got a few interviews scheduled as well. So
When are your interviews scheduled?
today and this weekend or tomorrow.
So we've had this conversation before, and I've told you that you've applied, and I've looked at your reapplication, and you still make more money than the minimum to have a court-appointed attorney. You understand that? Because you've reported that you have zero expenses. Because didn't you say you live with your father or something? You live with your father?
Yeah,
He pays all your expenses.
he does.
So all the money that you make can go towards an attorney. The value of your car can be sold. It can go towards an attorney.
It's only worth $1,300.
Well, I understand, but if you've got $3,000 in benefits coming to you, you've got $1,300 in a car, and you've got no living expenses, then all you have is income and no debt. And so state law says that it's going to have to be less, that your income is going to have to be a certain level above your expenses before the court is going to be able to find you indigent. So we had this conversation last time that you may have to sell your car.
But $1,300 doesn't help me get 10,000.
What kind of math is that supposed to be if you're short $10,000 and your car's worth $1,300? Then you're really only down $8,700, not exactly an impossible number to work toward. The smart move here isn't to complain. It's to get up, find a job, and use that car to actually make some money. That way you can afford to hire your own lawyer instead of expecting the system to do all the heavy lifting for you.
It doesn't. It helps you. It would help me get 10,000 because that's $1,300 towards that 10,000.
They haven't released the funds at all, and they're basically still reviewing. And the only money I had was the $111 from Abby's Bagels. So that didn't last very long because I asked them questions about their policy and they said that it wasn't working out. So
How much are you paying your bondsman?
paying what?
How much are you paying your bondsman?
The bondsman, I paid $5,000 total. But that was when I had a job. HEB supplied my ability to pay. That went away because they took hours away and I was driving too far. So I've been kind of up and down with jobs. Like I've had 3 jobs the past year and none of them have worked out very well. Just due to scheduling of new employees and overstaffing, things like that.
All right, Mr. McGregor, I'm going to reset you for 2 weeks. I want you back here on October 17th. You come back and you still have a car and you still have income and you have no expenses and you come back without a lawyer, we're going to have a hearing on your bond. I may find your bond insufficient that day and I may put you back in jail. And the longer you sit in jail, more likely you're going to become indigent to the point where I can appoint you an attorney. You see how that works? You're going to pay your bondsman $5,000. You're going to have a job, you're going to pay them $5,000 and you're going to get out of jail, but you're not going to hire an attorney to go forward on your case.
I would hire an attorney if I had 10,000 to come up with, but it's just not possible for me.
You've got a car and you're unemployed, right? So you got a car so you can drive to all these different places that are all looking for people to hire, right? Sounds like it's possible to me. So I want to see you back here in 2 weeks. If you don't have a lawyer in 2 weeks, then we're going to discuss your bond that day.
All right. That sounds reasonable enough. The judge is giving him a fair opportunity to sort out his legal representation before moving forward, which is generous considering the charges he's facing, but just when it seems like things are wrapping up smoothly, he manages to pull one more stunt on his way out. Whatever he does next clearly crosses a line, because the judge wastes no time having him taken into custody right there in the courtroom.
Bring him back in here when you get a chance, Fabio. Oh, yeah. Mr. McGregor, you've just disrupted court with your behavior today and your actions. Do you understand that?
I accidentally tried to open it the wrong way. I apologize.
I'm going to find your bond insufficient today. Deputy Martinez, go ahead and take him into custody. Mr. McGregor, I'm going to appoint you an attorney.
So I might as well have stayed in jail, basically.
But you're going to jail now, and I'm going to up your bail to $150,000. And and I'm going to appoint you an attorney.
150,000.
Yeah, that's what I said. 150,000, $150,000.
For opening the door the wrong way?
No, not for opening the door the wrong way. Do you want me to hold you in direct criminal contempt and sentence you to 6 months in jail, day for day, on top of a child charge that you have? Do you want that? Yes or no? No? Okay.
I apologize.
It's okay. Well, it's done. What's done is done. You'll learn your lesson, I hope. All right. Go ahead and take him, and I'll send over an order.
Well, that's certainly one way to prove you qualify for indigent status. Now, let's move on to our next case. This one's a real lesson in what not to do in court. We've got a man already out on domestic violence charges, and instead of keeping his head down, he keeps breaking the terms of his bond. But just when you think he can't make things any worse, he opens his mouth and says something you should never say to a judge, especially while standing in front of him in open court.
All right, let's go ahead and bring in Mr. Weathers, please.
Good afternoon, Your Honor.
Good afternoon, Ms. Conley.
Did you guys need Weathers, or what was the last name?
Yeah,
Weathers.
that's my turn.
Okay.
All right, thank you. You are Casey Lee Weathers, is that correct?
Yes, sir.
All right, Mr. Weathers, I'm Judge Elsenheimer. I'm handling this matter today for Judge Hamlin, who's unavailable. This is an arraignment on a motion affidavit and bench warrant that was requested by the prosecutor's office in Grand Traverse County. And sir, you should understand that, well, before we get to that, let me identify who's here. On your behalf is your attorney, Ms. Conlon. Ms. Copeland is the court reporter. Ms. Henry is the clerk. Mr. Olson is here from the prosecutor's office as well. Sir, the allegation against you is that you had positive test results on the 13th and 15th of October. You had a testing regimen that was part of your bond. The allegation is that you violated your bond, and violation of a bond can be considered to be contempt of court, which can be handled criminally or civilly. If it's handled criminally, it's a separate criminal misdemeanor, carries up to 93 days in jail, a fine of up to $500, but you'd have all the same rights you have in every other criminal case, including the right to an attorney. If you can't afford an attorney, one would be appointed for you at the public's expense. You also have the right to a trial. At that trial, the prosecutor would produce evidence to establish that you violated your bond. The standard of proof is beyond a reasonable doubt. You'd have the right to present your own defense, and if you needed someone to appear, I would order that to happen for that defense. If I thought that the prosecutor or Judge Hamlin thought the prosecutor had met that burden, he'd find you guilty. If he thought they did not, he'd find you not guilty. Ms. Conley, you've had a chance to discuss this matter with your client, correct?
I have, Your Honor. Thank you. Mr. Weathers would admit to the alleged violations at this time.
All right, thank you. So, Mr. Weathers, your attorney indicates that you're going to accept responsibility for the violations on those 2 dates. Is that correct?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, sir. I don't want you to talk about the domestic violence charge against you right now, third offense, or I suppose it's third or subsequent. We're not going to talk about that at all. We're only talking about this bond matter. Do you understand?
Yes, sir.
All right. The allegation is that you had test results on the 13th and 15th that were positive. It looks like they were positive for alcohol. Is it true that you used alcohol on those 2 days?
Yes, sir.
All right. So no surprise to you that you violated that you had positive tests on those
No,
days?
sir. Just
correct?
bad decisions, bad choices. That's it.
All right. I understand. All right. It's clear to me that you did violate your bond. I'm going to so find. Let's go ahead and have a conversation regarding bond going forward. Ms. Conlon, we'll start with you.
Well, Your Honor, Mr. Weathers has been on bond since on or about July 22nd. He's been compliant with his bond conditions up until these violations. He did, and he and I had a talk about this, Your Honor, when I got the bench warrant, and he admitted freely to me that he did relapse to alcohol. He had some stressors going on in his life, and unfortunately made a bad choice to drink, and he'd be the first person to tell you that. But other than this, he has done quite well on bond. He has not violated the no contact order at all, and he's been compliant with all of the terms. And he did turn himself in on the warrant, Your Honor. He is employed. He has jobs he can get back to if he's released. But we do have a final conference in this matter on November 8th, and then we've got trial dates in December. So we'd respectfully request, Your Honor, that bond be reinstated with whatever conditions the court would feel appropriate to ensure that Mr. Weathers does not drink again, including a CAM unit. He will gladly pay for and wear a CAM unit till we get this matter resolved in order to be free to work.
All right, thank you, ma'am. Let's go ahead and hear from the prosecutor, Mr. Olson.
Your Honor, I would note that the violation report indicated that the defendant drove off after providing a positive PVT. He was very close to the legal limit. We would have concerns about that. We would ask the court respectfully to impose a cash bond on this case. This bond was modified on September 27th to include additional conditions of no alcohol consumption testing. We did request a tether at that time. The court denied that on the basis that the check-in app has location data, but we would respectfully ask for a cash bond as well as a CAM unit that the defendant be required to wear.
All right, I'm concerned about even releasing the defendant whatsoever in this case. Looking at the reports that came in with regard to his testing, the prosecutor is correct. On the 10-15 date showed him at a 0.077. That is just shy.
Your Honor, I don't drive.
Whether you were behind the wheel or not doesn't really matter here. You shouldn't be drinking in the first place. You're already out on bond for a repeat domestic violence case, and part of that agreement clearly required you to stay sober and complete treatment. So if you were removed from that program after testing positive for alcohol, then you've already broken at least 2 major bond conditions. At that point, the issue isn't whether you drove, it's that you violated the court's trust completely.
Hang on, Casey.
Okay.
That is just shy of the 0.08 level. Maybe the defendant wasn't driving, but the indication from New Directions is that he left the parking lot at a high rate of speed in a dark Dodge. The indication also is that he was belligerent during the testing, that he did not comply with the urine screening, was unable to produce a specimen. I've got concerns about whether or not this defendant takes seriously his obligation to test. This is not a joke.
Absolutely.
Hold on.
Okay, yes, sir.
Hold on. This is not a joke. This is not something that is voluntary. This is not just a attempt to touch base with you and see how you're doing. This is a order of the court. And if you don't comply with it, then you can be held in criminal contempt, which is another 93-day misdemeanor. And frankly, you are getting awfully close to looking at that kind of response here. Having said that, I do think that there is an opportunity here to safely monitor the defendant and to keep the public safe as well. I'm going to go ahead and grant the defendant bond. I'm going to require that it be a cash bond. It's a $2,500 cash bond. I'm also going to require that he wear a CAM unit that will test his alcohol. If he tests positive at any time, or there's any issues with that CAM device, then it'll be certainly my recommendation to Judge Hamlin or any other judge reviewing that he be held until this matter is ultimately resolved. These are serious charges. These activities are serious. At least there's some evidence, hasn't been proven, hasn't been charged. You may have driven pretty close to being drunk. So I've got some real concerns about this, and I think that we need to keep a tight rein on you until this matter is ultimately resolved. If you have issues with my bond decision, you can bring them up to Judge Hamlin. I'm sure he'd like to hear from you. Is there anything else that we can address with regard to bond, Ms. Conlon?
Not for us, Your Honor.
Okay,
Can I
and,
speak to my attorney?
Mr.
Maybe we have a breakout room.
I'll allow you to do so. Let's go ahead and put
Thanks.
Mr. Weathers and Ms. Conlon in a breakout room, please.
All right. So he and his attorney step aside for a quick breakout session to go over a motion for bond reconsideration. Seems simple enough, except they must have skipped the part where the lawyer reminds him what not to say if the judge rules against him, because when they come back, let's just say his choice of words guarantees that things go from bad to worse in a matter of seconds.
All right, let's go ahead and go back on the record in People v. Weathers. We lost everyone for a moment, but Mr. Weathers back along with his attorney. They've had a chance to speak. Was there anything else, Ms. Conlon, that we needed to address for the defense?
No, Your Honor, Mr. Weathers was just wondering if you would consider a 10% bond for him, as he's unable to post the $2,500.
All right, let's go ahead and hear from Mr. Olson as to the modification of the bond request. Mr. Olson?
Judge, we would oppose that. In addition to that, Judge, I would also ask that I believe this is an original condition of his bond, but we would ask that this condition be applied both in and out of custody, that the defendant not have any contact with Emily Weathers, who's the victim in this case, to include through third parties or electronic communications.
That is, if it isn't, it should be, and is ordered to be an element of his bond in this case. I think, frankly, given the circumstances, that the bond level that I set was appropriate and proportionate in this case. It's sufficient to guarantee compliance. As a result, I'm going to leave that bond level where it is. So it looks like we're all set. Otherwise, Mr. Weathers, I'm sure that Mr. Judge Hamlin will see you soon. All right, take care, everybody.
Thanks, Your Honor.
Fuck you, Judge.
Woe caught on a hot MIC. And that little outburst, yeah, that's definitely going to cost him more than just a few harsh words from the judge. Moments like this prove that sometimes it's not the original crime that lands you in deeper trouble, it's what slips out of your mouth afterward.
Oh, hold on. Shoot. Let's bring him back.
You want him back?
I need him back. Let's see if we can bring Ms. Conlon back as well.
Your Honor, I was logging out when I heard Mr. Weathers' comment, and I assume you want him back.
I want him back, and I want him back. So then, all right, let's go ahead and go on the record. This is People of the State of Michigan versus Casey Weathers. The underlying file is file 24-15084-FH. The court had just ended the bond hearing when the defendant was being removed. He may or may not have been aware that the microphone was still on and picked him up, referencing the fucking judge. That is an act of contempt. It is contemptuous of this court and the court system. That subjects you, sir, to up to 93 days in jail, a fine of up to $500. I would note that this is direct contempt because it occurred directly in front of the court. The court therefore initiates summary proceedings and swears himself in. I do solemnly swear or affirm the testimony I will give will be the truth, the whole truth, and nothing but the truth. So as I said, I just completed the hearing on bond for Mr. Weathers. Mr. Weathers made the comment I've already referenced as he was leaving. He probably wasn't aware that the microphone was still on. Maybe he was. I know he's angry about the level of bond that was put in place, but he obviously showed contempt for the court. Ms. Conlon, do you have any questions for the court with regard to the statement that I've referenced on the record?
I don't, Your Honor. Thank you.
Mr. Olson, do you have any questions for the court with regard to the statement I've just referenced?
No, Your Honor.
All right. Do either of you wish to present any additional evidence at this time in summary proceedings?
No, Your Honor. Thank you.
No, Your Honor.
All right. Thank you. All right. I do find that the defendant is in contempt of court. This is direct contempt. It is a criminal contempt violation. The maximum potential sentence is up to 93 days, a fine of up to not more than $7,500 in this circumstance. I can also put the defendant on probation. There are no damages here. My feelings aren't hurt. So as I said, there's no damages. The defendant has had Ms. Conlon here present throughout these proceedings. Sir, you simply can't engage in that kind of behavior when you're dealing with court. I understand you're angry. I get it. Believe me, I deal with angry people every day. You just can't do that. That shows contempt for the court system. And I have an obligation, frankly, to that system to take appropriate action when someone is in contempt. Ms. Conlon, do you have any argument regarding sentence?
No, Your Honor, thank you.
Mr. Olson, do you have any argument regarding sentence?
No, Your Honor, thank you.
All right. Mr. Weathers, do you have anything to say on your behalf before I sentence you for contempt of court?
I apologize, Your Honor. I was out the door. I had no idea. This is all.
I know. I get it. I do. And I know it can be very frustrating. So look,
I turned myself in thinking I was doing the right thing, and now I'm just stuck. Like,
Mr. Weathers, you did. You can't, you can't say those kinds of things about a judge, even if you feel that way. You can't do it.
Your Honor, I don't even know you, Your Honor. I wasn't trying.
Right.
I just can't believe I turned myself in, and I thought I was going to be able to get back out. That's why I turned myself in. That's all. I guess it's just frustrating. I'm sorry. I'm sorry for taking my frustration out on you. It's not your fault. It's my own fault for getting myself in this position. I apologize, Your Honor.
I'll give the guy this much, at least he's owning up to it. You can tell he regrets saying what he said, even if that regret only kicked in after the fact. But the judge isn't swayed by apologies or excuses, and honestly, his reasoning for handing down the sentence is both sharp and completely justified.
I believe you, and I accept your apology. Having said that, the system does require a pound of flesh from you, and here's what I'm going to do. I am going to sentence you to 2 days in jail for this violation. You'll start serving that now, and that just means that even if you were able to come up with a bond, you wouldn't be able to be released for 2 days. I'm not going to assess you any additional fines in this case because I know that you're trying to raise money in order to be able to deal with your the bond that I've already put in place. I don't think it serves justice to assess any additional fines and costs against you. But Mr. Weathers, I will tell you that if you violate the law again like this, I mean, this is a misdemeanor violation. It's on your record now. If you violate the law like this again, you should expect a longer jail sentence and the possibility of a real fine. Do you understand?
Yes, sir.
All right. Very good. Thanks, everybody.
Thanks, Your Honor.
All right, folks. That wraps up today's courtroom chaos. 3 unforgettable moments, 2 well-deserved arrests, and 1 defendant who really redefined the word unbearable. Honestly, it doesn't get much better than that. If you enjoyed watching these legal train wrecks as much as I did breaking them down, make sure to hit that like button. If you didn't, feel free to hit dislike either way. It helps the channel grow. Drop a comment below with your favorite moment from today's video. And don't forget to subscribe with notifications on so you never miss the next courtroom disaster. I'm Team Skeptic. Thanks for watching, and I'll see you in the next one.